Hello, Carla Hartley here. Today I'm continuing our discussion of gray divorce and what that may mean or may not to you in light of some common misperceptions. So we have Bill and Melinda Gates with their dissolution proceeding heavily in the news. We have the Bezos marriage of many years breaking up, according to the news. I don't know for sure. And a number of other, well, I'd say an aging demographic, which has resulted in many cases where long-term marriages, very long-term marriages, are now moving into a season of divorce. The media has dubbed this gray divorce, and we'll stick with that. Today I'm talking about a series of common misperceptions, but today's misperceptions are focused on how people who've been married a very long time tend to interpret the property laws in community property states. So this idea that just because you've been married a very long time, everything is community property is erroneous. Now, I believe it grows from the legal principle that in community property states, everything that was acquired during marriage is presumed to be community property. The important word here is presumed, okay? That presumption, whenever you see a presumption in the law, you should know that it is a rebuttable presumption for the most part. If it's not rebuttable, the statute has to very clearly say it is not a rebuttable presumption. In this case, community property presumptions are rebuttable. Now, what do you have to do to rebut a presumption that an asset is community property? You need to trace it to a separate property source. So you've been married a really long time, you bought a house during marriage, and you're assuming that house is 100% community property. The character of the house is community property. That does not mean that the proceeds from the house or the value and the equity of the house is 100% community property. This is an important distinction, and it has cost a lot of people a lot of money because they enter into settlement based on facts and an interpretation of the law that they did not understand. And if they were mediating in a lot of cases, the mediator, whose job is to get the signature on the document, to get parties to sign and agree, that person isn't vested in making sure that you know your rights, that you know the rights that you're waiving. So if you are in the mediation process, make sure you have independent counsel. Don't just regard it as a formality. Have independent counsel look at this stuff and say, look, do you know what you're giving up here? Because you should know before you sign. Back to community property. So let's go through a few common scenarios. So you've got this house that you acquired during marriage, and then 10, 15 years into the marriage, you received an inheritance or a significant gift of some kind, or some other separate property contribution to you, something that came from a separate property source that was not to you and your spouse, it was just to you. We'll use an inheritance as an example. So this inheritance is deemed to be your separate property, and say you put that inheritance into the acquisition of the community estate, okay, or the pay down of the mortgage, not acquisition in this scenario. You put it into the pay down of the mortgage. Then 15 years later, now we're talking, 25, 30-year marriage, you want to, or you find yourself in a divorce. The house is community property, but you have a reimbursement interest and maybe a bit more of an equitable interest under some cases that have recently come down that are equivalent to the amount of the separate property that you can trace that you put into the community real property by paying down that loan. So that's a dollar for dollar reimbursement under current law, and under some extensions, there's a little bit of split of authority, you get more than a dollar for dollar. So let's talk about the next scenario. So you're married and you've been married for a while, but you had this separate property house that, when you got married, And after 10 or 15 years of marriage, you guys decide, you and your spouse decide to purchase a house together, and you sell the house that you owned before marriage, and you put that money, those proceeds, into the acquisition of your new property. That is traceable, and that is your separate property that has gone into the acquisition of community property. So yes, your house is community property, but you have a separate property interest in the equity or the proceeds from that house. Okay? These are distinctions, but they're big distinctions. This is not small by any stretch of the imagination. This is a significant problem. Okay, the last example I'm going to give you on this issue is another misperception about the character of property and what it means. So you've been married for 30 years. And prior to marriage, your spouse or you owned a rental house. You owned a house, you moved out of the house, you guys moved in. The community never lived. For purposes of this example, this does not have to be your exact fact pattern. Let's say just in this example, the community never lived in the house, okay? But throughout the marriage, that house was paid down. The rents say didn't cover the entire mortgage, and the community had to contribute for taxes, something like that. In that scenario, the community is getting, in other words, you are getting a reimbursement interest in the other side's separate property. And this principle can be extended, particularly where the parties lived in the separate property house during the marriage. Then that interest, it's called a Moore Marsden interest, gets a little bit bigger. Sometimes in a very brief marriage, this can be a relatively small amount. But in marriages of long duration, this can be a significant value. Now, I can mix and match various scenarios. I can come up with probably 5 others off the top of my head because all of these have been off the top of my head. The point I'm trying to make is not to give you a series of boxes to check. It's to give you the idea that just because you've been married a long time and just because you think you know the fundamental community property principles does not mean that you have no separate property interest in community property. And it does not mean that the community has no interest in the other side's separate property. What it means is you need to talk to somebody and find out. And you need to talk to somebody who knows what they're doing, not someone who's kind of a dabbler in family law, someone who does family law like we do. I hope this has been helpful. I hope you guys are going to have a good weekend. Thank you. Bye-bye.